I'm Kirk Snyder with Chorus Consulting, and I'm excited for you to see our Learning Forum series presentation on making or defending the proportionality argument. For this presentation, I'll speak about the 2015 Federal Rule 26 proportionality amendments, and you're going to see a presentation from the CEO of a company with a patented process to document and support a proportionality argument. And you're going to hear two experienced litigators, one who represents plaintiffs and one who represents defendants, discuss proportionality from their perspectives. Before we get started, for those who are not familiar with Chorus Consulting, we are headquartered in Houston, Texas, and we are digital forensic experts, data collection and preservation from servers, user computers, and smartphones. We provide data analysis to support proportionality arguments, and we are court-recognized experts. In December 2015, the so-called proportionality amendments to Rule 26 of the Federal Rules of Civil Procedure were amended. Despite all the press about the significance of the proportionality amendments, these proportionality factors are not new. Rather, most of the factors were added to Rule 26B1 in 1983. Both the prior language of Rule 26 and the case law demonstrate that proportionality, or undue burden, has long been a key component for evaluating the reasonableness of discovery requests. Unless otherwise limited by court order, the scope of discovery is as follows. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. However, consideration will be given to the importance of the issues at stake in the action, the amount in controversy, the party's relative access to relevant information, the party's resources, the importance of the discovery in resolving the issues, and whether the burden or expense of their proposed discovery outweighs its likely benefit. So, a proportionality argument is not necessarily just about the volume of data and cost. It could also be about redundancy, the same data from multiple sources, or inaccessibility. The data can be retrieved, but will require extraordinary effort and expenses, perhaps by a third party. Or relevancy. The data requested does not even support the issues of the case. The bottom line is the requesting party bears the burden of establishing relevance, and the objecting party bears the burden of establishing the discovery is not proportionate to the needs of the case. To meet the burden, a zealous advocate should be prepared to offer fact-based proportionality arguments, whether the attorney represents the requesting or the objecting party. Next, Mandy Ross, CEO and Managing Director of Inside Optics, is going to show and tell how their patented process documents a proportionality argument.
Well, hi, my name is Mandy Ross. I'm the CEO and managing member of Inside Optics. I want to say thank you to Chorus Consulting for asking me to participate in this discussion. So today we're going to be talking about the continuing challenges that we see in e-discovery and how a change of focus to the identification stage pre-collection is the key to moving the needle on applying proportionality and right-sizing discovery early. So let's start with where the market is today. The focus on reducing e-discovery spend has traditionally been around technology that is used post-collection. And so even though we've seen advances in technology, we still see e-discovery costs continuing to increase, with an estimate of $12 billion in 2022 up to $15 billion in 2025. So why is this occurring? The explosion of data volumes and complexity of emerging data source types have increased these costs and also increased risk for corporations. And we still continue to see a trend of weaponizing discovery and discovery disputes around what is exchanged in the context of productions. In fact, We've seen a 285% increase in e-discovery disputes around scoping and proportionality over the last 5 years. So absent addressing the root cause, which is scoping the data pre-collection, we're going to continue to see that costs will accelerate. So let's talk about the electronic discovery reference model and where the blind spot exists today. So when a legal trigger occurs, the standard approach is to cast a broad net, issuing a legal hold notification to any and all potentially relevant custodians. And as part of this legal hold notification, it's also fairly common to distribute a questionnaire to the employees, asking them to provide information about what they deem to be relevant, unique data sources and locations. And these answers then become the foundation for a data map and informing what data is collected and moved downstream. Custodians don't necessarily always know how to evaluate what constitutes a relevant or unique data source, which consequently leads to seeing large volumes of non-relevant or marginally relevant data moving to the more expensive stages of discovery. The focus in the industry has been on reducing the volume of documents that move to the review stage, which currently is where we see 68% of discovery costs overall. So let's illuminate the blind spot. The key to solving the e-discovery cost challenge is to address the root cause by taking advantage of the proportionality permission slip to narrow the scope during the identification stage. There is a significant opportunity for in-house legal teams and their outside counsel to leverage the identification stage to evaluate and surgically reduce the custodians and data sources post-collection using a defensible framework that aligns to the federal rules of civil procedure as well as many of the state court rules. This pivot in thinking will save millions of dollars for your average large corporation. So let's talk about that permission slip. Proportionality has been embodied in the federal rules dating back to 1983, but in 2015, they were updated with a focus to allow litigants to drastically reduce the scope of discovery. Rule 26B1 was reworded to state that parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense and proportional to the needs of the case. This replaced the language that used to state that anything that was reasonably calculated to lead to the discovery of admissible evidence. Now, in addition to the rule change, there were also 6 proportionality factors that were incorporated, and those are shown on your screen. But the main factors we're going to be focusing on today are relevance as the threshold, evaluating burden, looking at expenses and costs, and then also evaluating that in the context of the amount in controversy. So although the rule amendment was really intended to help litigants drastically reduce what they were spending on discovery, there's been a gap with practitioners where they've really struggled to take proportionality from a concept to an actual framework, starting at the outset of a matter. So how do we deploy such a framework? Insight Optics created a technology-enabled approach called Evidence Optics to provide this framework for legal teams. There are 3 components to the workflow. The first is to interview and evaluate. The second is to strategize and budget, and the third is to centralize collaboration, including data source tracking and logistics. During the interview and evaluate stage, there are 3 metrics that are created pertaining to custodian relevancy, data source burden and effort, and cost estimation. So the first component is to understand our custodians and data sources. We're going to conduct a 5-minute assessment interview to score and rank custodians based on their relevancy to the claims and defenses, using a scoring mechanism to create an overall relevancy score. This is our first slice at reduction, because what it allows us to see very clearly are the custodians that are most relevant to a matter, while also partitioning out the custodians who are marginally relevant. This prioritization can also be used to make determinations about who should move to the secondary interview process. The secondary interview is intended to allow the legal team members to interact with the custodians to identify and score data sources based on the burden and effort of collection, while also eliminating non-relevant and duplicative data. And so you can see again that we're classifying our data sources into these burden categories, which again allow us to focus on the orange sections, which are the easy and medium data sources, and carve out those data sources that are more complex so that we can perform further evaluation. Each data source category also has a cost projection, which includes the dollars it will take to move data from preservation all the way through review and production. And this cost metric is then used to build budgeting scenarios. The metrics become the foundation for moving to the discovery scoping phase. So let's take a look at that now. So as interviews are completed, the custodian rank and data source burden scores roll into this heat map. You can see that relevance is plotted on the y-axis from priority relevance at the top to low relevance at the bottom, and burden and effort are plotted on the x-axis from low or easy on the left to burdensome on the right. You'll also notice that each quadrant in the heat map has a dollar amount associated with it, which essentially gives you the estimated cost if you were to move all of that data through the discovery process. So this particular facet of the workflow can be used in a couple of different areas. First and foremost, it can be used for early case strategy to inform decisions around whether you should settle a matter versus proceed. It can also be used for internal discovery scoping and budgeting. When you get to the point of negotiation with other parties or the 26F conference, this can certainly be used to create hypothetical scenarios so that you can evaluate the scope of a discovery and the corresponding spend. And then you'll see in just a moment, but the metrics and the decisioning become the output of the model, which can be used for documentation if judicial intervention is needed. So let's go ahead and take a look at these different quadrants to kind of talk about how you approach your discovery strategy. So the upper left quadrant is really the center of the bullseye. Highly relevant custodians, easy to gather. So from a standpoint of prioritizing, we would want to start by looking at custodians and data in this particular quadrant. The upper right quadrant is priority, relevance, and burdensome. And here we get to really evaluate whether the evidentiary value and the costs associated with moving that downstream align to the merits of the case. And so rather than just moving this forward, we want to be much more tactical about what we do in relation to perhaps looking at sampling, cost sharing, or cost shifting. And thanks to advances in index in place that allows us to basically search content behind the corporate firewall, it's a lot easier for us to kind of look at the story within the data to make informed decisions about whether that data should be moved forward or be left behind. Now, where you get the most value is when you look at these lower two quadrants, because in the prior workflow, often this data that's classified as low relevance data does move downstream to the more expensive stages of discovery. But what we're suggesting here is that since we already have attorney oversight who has made decisions about the fact that this is of marginal utility or relevance, that ideally we want to leave as much of that data behind. And so using index and search in place, certainly we can use this to evaluate and create an exclusionary strategy to be able to demonstrate there's nothing highly substantive that needs to be contemplated in these lower two quadrants. It's important to note that when you're scoping, it needs to be based on fact finding and information, not speculation. And what we've heard on a consistent basis from the judiciary is that lawyers really need to show their work when making a proportionality argument. So let's take a look at the output of the model. So what you're looking at here is a hypothetical scenario that a defendant has prepared that outlines information around the custodians, their relevancy rank, the data sources, the burden and effort, and the cost associated with moving that data forward. So this is really the information that is needed to quantify your discovery plan based on your decisioning and the metrics that you've constructed. These scenarios can also be used to demonstrate what other parties are requesting in the context of litigation. So, for example, if an adverse party is requesting $300,000 on a claim of $500,000, being able to present this documentation allows you to demonstrate that the requests are disproportionate to the amount in controversy. This really allows you to create a roadmap around your discovery plan that is proportionate to the needs of the case. So once you've completed your scoping plan and you're making decisions to move data forward from a standpoint of preservation and collection, we move to the next facet of the workflow, which is all around centralized data tracking and logistics. Corporations, law firms, and providers have lacked the tools to maintain sound documentation around preservation, collection, chain of custody, along with data return and disposition. Historically, this process has been unstructured and decentralized, typically controlled by both in-house teams, including legal and IT and e-discovery, along with their outside counsel and also their vendors. And traditionally, the documentation is something that's managed through what we call the traveling spreadsheet, which makes it very difficult to stay up to date on all the moving parts in relation to what's happening, because of the fact that you don't have access to real-time information. So as you make decisions to move data forward as part of the scoping process, Evidence Optics facilitates centralized collaboration with all team members, provides the tools that are needed to manage and track data sources and collection details across the litigation lifecycle. It enables the corporation to take control of all decisioning across not only their active litigation portfolio, but also serving as a historical record for any matters that are inactive or closed. And lastly, it provides real-time automated stakeholder reports along with progress and task reporting to keep all team members up to date on the current progress of any particular matter. So a few takeaways as far as what we've kind of talked about today. Remember that permission has been granted. Utilize the rules to your benefit to deploy a reasonable discovery strategy. The other thing that's important to remember is that discovery is an iterative learning process. You really want to start early, and then as you learn more, you want to document, audit, and calibrate and refine your decisioning as the discovery process progresses. And certainly having a strong written record of the entire workflow provides defensibility of process and information that may be referenced throughout the life cycle of a matter. As far as the metrics are concerned, remember they don't need to be perfect, but they need to be based on attorney decisions and actionable data points. And then lastly, I would say that having a consistent, repeatable, defensible process to scope discovery is essential to not only rein in runaway e-discovery budgets, but it will also assist in mitigating risk for both corporations and their counsel. So with that, I'd like to conclude today's session. I want to thank Course Consulting for allowing me to participate in today's presentation. Have a great day.
Next, we will hear from two attorneys regarding Rule 26 proportionality. Jay Munisteri will be speaking from the point of view of an objecting party. He is an active trial lawyer in Houston, particularly in the areas of energy litigation, international dispute resolution, corporate governance disputes, and in cases involving the laws of multiple and international jurisdictions. Jay has been practicing for more than 35 years. And then Alexis Conan will be speaking from the requesting party perspective. He is an attorney with the law offices of Colby Lewis. He earned a JD from the University of Houston Law Center. Alexis has been active in the legal field since 2014 and was recently admitted to practice in the state of Texas. This is what the lawyer said when asked, "Tell us about a case where proportionality impacted the scope, size, and ultimate cost of discovery."
So I won't name names and I won't get too specific, but I mean, we've had a case since the 2015 amendments where the plaintiff's strategy was essentially to name multiple executives up the line all the way up to the chairman of the board. In a case that had facts that at first blush seemed pretty compromising, but when you actually got into the facts were frankly pretty defensible. However, the strategy was to basically make the defendant and each of its affiliates and all of its executives search and search and search. And proportionality probably did not enter the picture early in the case, but as the additional defendants were named and as we kept having to produce similar or look for similar categories of documents, we asserted the proportionality objection to the magistrate because that magistrate had already been through a number of other discovery disputes that related to privilege and relevance. And so by the time we got to proportionality, that magistrate had been educated enough to understand the case had really been discovered, maybe not extensively, certainly not in the plaintiff's view. From our view, it was. So where proportionality helped was being able to show that we had made the objections originally, produced some documents, and then as we got farther into the case and new parties were added and they came back, the plaintiffs did, and moved to compel, we focused heavily on proportionality because it was asymmetrical between doctors versus a large hospital system. It was asymmetrical and burdensome, and that's really the question. This is not a new question. It's an undue burden question. And,
right.
and whether we have the burden or whether the requesting party has the burden, and I think necessarily the party who's raising the objection is going to have to show it anyway. And so we used experts from the discovery support vendor who testify regularly. We identified the costs. We had the affidavits, all the things you normally do. And we litigated that issue and frankly got good rulings. And proportionality was ultimately where the court came down. And, you know, some courts will go through each of the factors, as they should, and identify it. And the briefing does that. But I think when you distill it down, it's really how does a judge react when they see what's going on in the case, what they know about the case, and does this appear to be something that's really needed, or is this just someone just trying to, pop a defendant and make them scream with cost? And or another way to look at it, and there's a Harris County district judge that used to say this is, you can't always get what you need, but sometimes you can't always get what you want, but you get what you need, and that's what I think the proportionality issue can come down to.
Yeah. So to go over what you're saying, Jay, ironically, so I think, I have the optic experience of exactly what you're discussing, where in a practice we've been doing, the defendants in that case were a large corporate entity, and they had exceptional resources, but it was due to discretionary choices. And this situation we had continuously asked and for production of various documents and information and underlying data. But the rather interesting stance was that, they could not verify that these things did not exist, but at the same time, they could not locate them and produce them, which put us in this weird limbo. And in these situations that we had, I guess, run into, an interesting situation happened was, we had to then evaluate, what's the viability of really getting the discovery we need to support our underlying claims. And then that's really when the entire proportionality issues came into play and the burdens on the parties, us representing, just individual versus against this corporate entity. And I think one of the interesting things that I think in the future is going to be a crux of the arguments that are had under the proportionality rules are not just the undue burden with respect to what extraordinary measures may have to be taken to satisfy these discovery needs, but also that has to be balanced with, what conscious and discretionary decisions were made in choices of, overall data storage, retention policies, etc., that led to that situation. If it was a predicament that I'm making, that's where this one narrow exception to the rule falls out, where the burden then of all those costs would fall on the defendant, which is something that I'm very interested to see and discuss more in the future to see, how the defense counsel, the defense bar evaluates that as well. Because as I've seen so far, there are some corporate defendants, I guess, in the PI context that are have expansive resources, are large multi-million-dollar companies with all the proper network topology and everything necessary to retain these documents and accurately respond to discovery. Whereas there are many corporate entities out there that are mom pop shops, and they may be successful, but they lack the internal infrastructure for that. And then when something happens and they have to actually respond, everything's in disarray. Now, is that really then a burden of my client who suffered due to the negligence of this corporate defendant, or is that predicament of their own making something that they should have to pay for because they failed to actually keep up to date with their overall network services and topology and retention of data underlying their business operations? So, that's definitely, I think, something that I am looking forward to seeing in the future. But that's been something we had to experience in one of our cases. And ironically, going back to costs, that's it kind of came back to haunt them because this issue that arose with the inability to locate things. Well, if the company itself is unable to keep up with standard and modern day times with these standard business operating procedures, they're going to be on the hook for those costs. Inevitably, that's what happened in that case. And it was unfortunate. I thought it could have been avoided, but then lo and behold, that's what happened. So, on my end, I'm always looking forward now to seeing, what that actual balancing effect is going to be with respect to extraordinary measures and the search terms used therein to get what you really need.
I want to thank Alexis and Jay for sharing their perspectives regarding proportionality, and a special thanks to Ray Beacon, our Director of Sales and Marketing, for arranging these interviews. But before we close, I do want to amplify the point Alexis made about how a requesting party might defeat a cost shifting argument by the responding party by proving the responding party's own mismanagement of information was the cause of the requested data to be inaccessible. It's my belief that in house and outside lawyers don't realize that information management is a huge corporate vulnerability and potential liability. And most corporations are not prepared for a 30B6 deposition to justify their actual data management practices compared to their policies. Chorus Consulting can not only help preserve or analyze all forms of electronically stored information, we can also provide expert testimony to defend or defeat a cost shifting argument from opposing counsel. We hope you found this presentation insightful. Please contact me at ksnyder@chorusconsulting.net if you have any questions or wish to receive more information.